So another thing that I just want to mention about the opening part of the Bill of Rights, it actually does say, the heads of Declaration of Lords and Commons recited, right? So the heads, so when I said in the last video, not declaring the rights and liberties of the subjects and the settling of succession of the crown, the settling of succession of the crown, like I said when I put the red spot there, it's all about the rights of the subject primarily. I know it goes into the subject's rights later on, but that's what the whole thing's about. And it goes the heads of Declaration of Lords and Commons recited. So I still believe these first opening parts, these are clauses like later on, but they are, I think they're helping, set the context and understanding of the whole thing, rather than kind of like being at the end. So hold on a second. I just got these all set up. Right, so I've just got these meanings up here, and I know that we know what they mean, but I just thought I'd get them up here. Diverse, arbitrary, and courses, right? So we know what these all mean: arbitrary, diverse, and courses. A course is a route. So like, you've got like a course where, you might send bicycles around the course, or, a ship might go in a course around the island. But we're talking about prosecutions. It's all about prosecutions and Parliament. By prosecutions in the court of the King's Bench for matters and causes cognisable only in Parliament, and diverse and other arbitrary and illegal courses. So the cause, our cause is usually our campaign. Our cause is most usually always our campaign, or something that has caused the campaign. The cause, you're fighting for a cause, but also what even caused these matters. So it is when you're trying information in a court, or if you're hearing any matter, or if you're hearing any subject, that's your cause. All these protesters have a cause that they are campaigning for, and also that matter caused them to campaign, which we kind of, I know this is kind of like more explanatory, right? Now, when it says, I think that these diverse and other arbitrary and illegal courses, so the thing is, usually, if it's illegal prosecutions, that is making it illegal. You're only prosecuted if you've done something illegal. You wouldn't have a prosecution if something was lawful. So it's forbidding prosecution to be used. Although so we know they were prosecuting people just for having meetings or speaking freely or even supporting a cause or whatever. But petitioning itself wasn't illegal, but they were trying to, prevent them from bringing certain matters. But also we know it covered the rebellious. There was lots of rebellious behaviour and other actions going on. And why would they create a law that made it petitioning illegal if there were, all prosecutions? They didn't need to use the word all prosecutions. they most definitely had a lot of different words available to them even back then, and they didn't need to put in all prosecutions are illegal. They could have just put, certain ones or some of them, but they said all of them for petitioning. And we know from that other act that, it's definitely covering all this behaviour, this, rebellious behaviour and so forth. And, going about, speaking and also gathering together, because they even put a restriction on, prior to this act that we're looking at now, with this tumultuous act, they put a restriction on, the numbers of people and so forth. But later on, they've definitely made it illegal for prosecutions. But I think that it's because it's prosecutions in the court of the King's Bench, illegal prosecutions by prosecutions in the court of the King's Bench, for matters and causes cognizable only in Parliament and by diverse and other arbitrary and illegal causes. So the thing is that the courts were, it wasn't like we have courts now. They didn't, all these different courts they've got all around the country permanently, like county court and magistrates court. They had the judges had these circuits. The judges had circuits and travelled around a course. The judges had circuits. So the circuit is the course. Well, when you're talking about prosecutions, you're talking about circuits and courses, right? But they're fixed circuits and courses, but they go about judgments. They're travelling around and going from place to place, and they finish up at the Tower of London in these courses. That has got something to do with the wording. It's got something very significant to do with the wording of this. Something very, very significant. And also, diverse is a great deal of variety. Diverse is something that might have a great deal of variety. So when you're doing these causes and campaigns, there's a great deal of variety of subjects, matters, causes, and ways people go about engaging. There's a diverse number of ways that people go about engaging with these causes. Like, going out in the streets, having meetings, all these rebellious behaviours and so forth. There are diverse ways that you can engage in these matters. And arbitrary is whimsical. So it's based on personal choice or whim. And the petitioning is whimsical. It's to what matter to you. What causes concern the person and how they will engage with them, or where they'll go about getting help or evidence or whatever, is their whim. But the one thing that is in common is that they are definitely petitioning it or bringing a grievance to the Parliament, right? And they're wanting the Parliament to make a decision on it, cognise, decide, think about it. Cognizable is debatable and decidable in the Parliament. In the Parliament, because that's where they're sending it to, that's where they're addressing it to. And the Parliament is, the Palace of Westminster is a jurisdiction that is above all the courts, above the circuit of the King's Bench, the normal circuits of these judges and magistrates, justices that are travelling around the country in the normal courts procedures. Now, we had those Lord of the Articles who were checking the petitions, and we had, in the Tumultuous Act, we had the justices or a grand jury who were looking at it. They weren't deciding it, though. They weren't deciding the petition. They were just having to check it and approve it. And I think I think that Karen mentioned a fee as well at one point for submitting them. They were charging. And then we've got as courses are definitely his roots and so forth. The thing is, you go about different routes and about different courses when you're going about getting public support and signatures or even getting evidence. You've got to go around your own courses. But you are bringing a case. Ultimately, you are bringing a matter, you are bringing a cause, and sending it, addressing it to either of the Houses of Parliament or the King. So you've got this illegal prosecutions gets a little bit, I think it's meant to be poetic, because you've got the courses and the tracks, the routes of the justices going around the country, who they decide the normal criminal matters and the normal civil cases that people are bringing to the King's Bench. But it's not a case that they are, it's not a criminal case or a civil case that you are addressing to the Parliament. It's a matter only decidable by the Parliament or the King, because that's who it's to, not to the justices. I'm sure that is what it is, because they had those committees in Parliament when Parliament was formed. They had the committees, and when Parliament wasn't formed, they addressed it to the King and the King's Council, Privy Council, but you still had. There wasn't the Parliament formed to be able to have committees or the ministers process it. So you have these Lords of the Articles or, grand jury and 3 justices to check them and process them, to sending them for decision making by the Parliament or the King. That's how I see it. If you can understand what I mean, to me, it's the difference between, you've got a magistrate's court, or then you've got a next level, you've got the Crown Court, and then you've got the next level, and you've got a High Court, and then you've got the Palace of Westminster, which is meant to have a judicial function. And the courts don't make decisions over getting laws made or changed, or grievances that people are putting about the country to the King, or even when you're going about giving evidence to that, or addressing your disapproval, and all facts and circumstances concerning the courses you're going around in your arbitrary, whimsical ways to go about doing this they're a case, they're part of those proceedings, are a judicial process. So if there are any misdemeanors or incidents involved with it, it's almost like a police investigation, the police's actions and so forth. Really, if you want to question the police's conduct in a case, if you've got a lawyer with you, if you've got the means necessary, rather than sort it out at a later stage, you would address all the conduct of the police going about their actions in matters and facts and circumstances concerned with your case. In your case, rather than, if you're mistreated, you can get a solicitor to bring, professional negligence, or actions against the police can be brought, and usually are brought later, but only because they were overlooked or weren't addressed in the case. If you're being prosecuted and the police have broken the law or mistreated you and so forth, and all that is known, and your lawyer's aware of that, or you're doing your own law, usually the matters are facts and circumstances involved with your case, and it would be addressed as part of your case. And the magistrate could refer matters, to a county court, or take action against officers if they broke the law, or so forth, or had misdemeanors or broke warrants and so forth. As part of your case, if all those facts and circumstances are known at the time, and I think that all the facts and circumstances of the petitioning, really, it is all part of a set of proceedings that are through a jurisdiction and authority to the Palace of Westminster. That's how I read this, and therefore, really, our elected MPs are the equivalent of our lawyers, really. They debate our matters. We're meant to elect them to represent us in Parliament. Unfortunately, what's happened is with these political parties, they end up being affiliated with and upholding their political parties more than the people who elect them. Really, that's the main problem. So we're not really getting a fair representation in Parliament, particularly in the Petitions Committee or in debate anymore, in our own individual matters that we've got a right to petition about, which supersedes and predates even calling a Parliament and having a Parliament, or even electing these MPs to represent us. And they're really trying to undermine that and take over the Parliament, really, with mainly their political parties. I don't think it was as bad, when you had, before the Civil War, when Oliver Cromwell and certain persons were elected purely to represent their own areas without the political party. The political party affiliations has really kind of messed up the whole thing, because these people we elect are not really doing us any favours or assisting us. They're actually opposed. When you elect an MP, there's nothing worse than having an MP opposed to the people he's meant to be representing. And that's why I think the weight of the signatures in petitions, when you get 100,000 signatures, it outweighs the vote. When some of these MPs get elected, many of them are getting elected on less than 100,000 signatures in their constituency. And when they're not really representing the people so much as their own parties, when you are petitioning a single matter, a single cause, a single case on one thing that is of importance, and you get over 100,000 signatures on it, the weight of the public concern for that matter outweighs the public voting and support that the MP received to get elected. So you are really, the weight of that case and cause is compelling your local MP, or at least, the Parliament. The weight of the jury, the public jury, is outweighing the power that elected the MP to represent you for their elected term. This one subject is of grave, crucial importance, and you're proving that with the signatures and also the evidence as well. But it can be heard on the weight of the evidence without the signatures. But when you have the public concern, it's actually putting more precedence on that matter than on the actual authority of the MP, really. That's what I think. So I think all these whimsical and arbitrary courses, the matter still comes down to, can you be prosecuted by the Parliament if the King's Bench courts or the circuits can't prosecute you or imprison you? Is it illegal for the King or the Palace of Westminster to make criminal orders against these petitioners? Magna Carta said that barons, lords can only be judged by their equals, but they can still be prosecuted for their work in Parliament or even in their lives. So that's the question. So when you get down to, interpreting the right of the subjects, when you get down to interpreting the right of the subjects, that is the right of the subjects to petition the King, and all commitments and prosecution of such petition are illegal. It says all of them. It says all prosecutions. So, it would seem that the right of the subjects, and that's what the whole act's about, it is overriding, really, like an overriding objective. But as it describes illegal prosecutions, are these illegal courses the circuits of the judges that might be used? But then, otherwise, our acts and actions may be illegal or unlawful, but, because we're petitioning, it makes them lawful, and it makes the prosecutions illegal. Is that what it means? I think that, many people could debate and argue over this, but I think that the historical context does solve the problem when you know what's happening and what's going on. I think there's no doubt that our actions out in public are part of our proceedings and should be decided and debated along with our entire case, the Palace of Westminster. Whether or not we can or cannot be prosecuted by the Palace of Westminster or the committees, like they've got privileges committees for themselves, we should have privileges committees. I don't really know. That is the ultimate debate. I guess that's the sort of thing. Look at Trump now with impeachment and so forth. That's the question.